my good colleagues, distinguished participants, esteemed colleagues and friends, it's my great pleasure to start the last session at this long yet very stimulating long day. The topic of our session is legal reforms and democracy. And we have excellent speakers. I will present them in the beginning, and then I will call on them only by name. Professor Ruti Teitel from New York Law School will speak on judicial independence and democracy preservation on militant democracy. Professor Teitel is one of the world's leading authorities on transitional justice, human rights, comparative constitutional law. I just attended a small workshop in New York City on her new book, which I heartily recommend. And I read from cover to cover. I was particularly interested in the difference between the post-World War I and post-World War II, and I was fascinated by the analysis. And she directs the Institute for Global Law, Justice and Policy, and is the author of seminal works that have defined the modern field. Professor Chaim Zandberg, Zandberg or Sandberg? Zandberg. I'll tell you what. I'll tell you. My address in Jerusalem is Elza. In German, you write it with S, but you say in Israel, Elza, but it's Elsa. Okay? Never mind. This is only a cultural gibberish. Professor Sandberg will speak on judicial protection of private property in complex contexts. He is a professor at College Management of Academic Studies in Israel. He is a prominent scholar of Israeli land law, author of Land Law and Policy in Israel, and researcher of both Israeli and Palestinian legal systems. This is one of unique people who study Arab cultures. Many years ago, I wrote an article, Civil Rights in Jordan. I was mentioning in the corridor that I once was in charge for the International Association of Procedural Law on judicial discretion. I was general rapporteur for common law, but they asked me to do Middle East. So under the authority of Professor Marcel Storme, who was hosting the 50th anniversary of the IAPL, which is the International Association of Procedural Law, but 500 years of University of Ghent. So it was in the same event. And I was charged with collecting the reports and analyzing from the Middle East. Israel, Middle East. I received no report from any country in the Middle East. It's regrettable that they don't study and they are not active in academia. The other speaker of today is President Hiram Chodosh, who is president of Claremont McKenna College in California, United States, and he is also vice president of JIWP, and he hosted two conferences, one in Utah and one in Claremont, California. So you see, each one of the people gathered here made his part, his share, to continue this important activity that we carried on for for now over 40 years. Can you imagine? President Chodosh is an influential academic leader, an internationally recognized reform innovator, known for his work on conflict resolution, mediation, institutional improvement in emerging legal systems, and leader in higher education in United States and elsewhere. He will be with us online. Also will be online Professor Eric Helen. He's from Claremont McKenna College. He's professor of economy. He is also senior economist at Rand Center. And he is a co-editor of the International Review of Law in Economics with many numerous publications on empirical legal analysis. And I want to mention that he edited volume number 6, co-edited together with Hiram Chodosh and myself. And then we have another host of the international conferences. He hosted in University of San Diego, 2013, well attended. Professor Maimon Schwarzschild, he is at the University of San Diego, California, a distinguished scholar of constitutional law, jurisprudence, law and religion, and an experienced practitioner both in the United States and a barrister in the United Kingdom. And then we have a host that is sitting with us because we are all coming from overseas, and you are local, yes, but we appreciate, yeah, Neapolis University in Paphos, Dr. Elina Asimkopoulo, I pronounce it correctly. That means I belong to the region, only for 50 minutes flight. From London, it's 4 hours. Yeah. From Malta, it's 2.5 hours. And Ruti and Maimon went all the way from the United States. That's why you are very local. I'm semi-local, and they are very remote. So Professor Kyriaki, no, we haven't said some words about you, because then the next one is Kyriakidis. A professor of procedural law, she is author of multiple books and a frequent instructor for judges and prosecutors at the Greek National School of Judges. And then after the presentations, we will have the privilege to hear the concluding remarks from Professor Nicola Kyriakidis, who will be wrapping up the conference with his comments. Before going to the presentations, I want to show you 4 or 5 slides relevant to how to judge legal reforms according to what has been shaped in international standards. So when you judge reforms, it is usually national jurisdictions, and then you compare them with what the international standards. Now the question is, what approach do you adopt? Do you say, okay, we have universal standards, everyone has to follow, or you have to take into account local circumstances? So the universal approach says universal, we don't compromise. The other approach is called particularity approach. Why? It takes into account the particularity of each of the systems that you are assessing or evaluating. So the first slide I want to show you is Standard 1.3a, which was adopted only 3 years ago in Jerusalem, because we amend the from time to time. It is possible that we will offer one amendment, because the only one who suggested an amendment was Daniela Piana. He suggested, and she suggested an amendment, and I will talk to her tonight to ask her to draft, and then I will spread it not only with this group, but for the others, and then by the end of tomorrow we'll approve it. So each time we add. So this one was added in 2022 in Jerusalem. And so it says it goes according to the particularity, not to the universal strict approach. It says, look at the D, we must take into account circumstances in each jurisdiction and recognize that in some countries it is justified to exempt certain practices from universal standards. I think Matthias would be happy with this text when he hears it. This is in spite what I said, that you have to be, the court have to be the last line of defense. Yeah, but this is recognition that the Supreme Court and the national jurisdiction should be respected and taken into account. The rule should be qualified so as not to accept legislation or judicial decisions that, when carefully examined, are predominantly motivated by improper aims to interfere with judicial independence. This is a very important point, and this concept is accepted by Standard 38 of the ELI Mount Scopus standards. The ELI Mount Scopus standards also says the same. I'm reading from 38.2. Current and proposed state actions must be assessed to determine whether they are intended to undermine judicial independence or other fundamental values of the justice system. That means if someone brings to you a reform, say it is in Germany or it is in other countries, if it is accepted there, you have to accept mine too. That was the Polish argument. We have, what do you mean higher council? What do you mean judicial selection? We are not doing much. Look at other systems. The answer is, you have to look overall what is the intention. And it is, for example, our crisis in Israel. They trying to say that it is, look innocent and acceptable. And finally, the last point I want to show you is that not only the ELI Mount Scopus accepted this principle, but also the report that the Charter on the Constitutional Fundamental Principles that Takis Trimidas led with the ELI also accepted this principle. And I want to quote one paragraph. So it says, it is not a section, because they didn't write standards. They wrote chapters by chapter. They are different from our report on the ELI. It says, judicial independence must be guaranteed not only as a matter of law, but also as in practice. Furthermore, in determining whether a specific rule may violate guarantees of judicial independence, an overall evaluation is necessary where account is taken of the objectives of the rule, the rationale, and the true reasons of its adoption. So I think that every one of us who analyzes legal reforms, on the one hand, has to be cautious and respectful of local circumstances, but on the other hand, when analyzing the legal reforms, one must also check very carefully, and I would say even aggressively, the real motives behind the reform. And we heard today so many suggestions, and all those have to be examined according to the analysis that I suggested. So now we start with the real presentation. Mine was just, an appetizer, or as they say, when they have a very important singer, they have someone who is of lesser importance who come and give few songs before the real
Warms up.
warms up. So I was the warmer up, and you are now the main courses. So Ruti, please, you are invited to give us your presentation.
Thank you very much. Can you hear me? Is it? Yeah, it's good. Okay.
Yeah, 10 minutes is the format that you have already
Okay,
heard. I
yes.
will continue
I will do my best.
tradition,
Yeah.
but maybe I'll be less aggressive than some of the chairs, because this last session, so we have to be.
That's a new interpretive principle.
If you sit
Okay.
all day, you need to be flexible. Yes.
Okay. So what can the judiciary do to protect democracy? We've been talking about a number of different mechanisms, and I want to refer back to Dr. Shetreat's introduction, where he talked about critical events happening in Europe in light of diminishing democracy, but he also mentioned the United States. So as one of the few here from the U.S., we have to, my comments will be comparative. Over history, different moments have arisen where we have thought about independent judiciary as a bulwark, as the possibility of saving democracy by limiting democracy. What does this mean? It seems conclusory and paradoxical, and I want to suggest that implies many assumptions about the judicial role and the judicial enterprise, and just share with you, discuss from a comparative perspective, some of the dilemmas of what's called militant democracy. I'm just trying to fit 9 minutes, summarize an article in Michigan. So anyone who's interested in the longer version, I'm happy to share it. So what's the conception of the judiciary that would deliver democracy while limiting it? And I want to suggest that this is a very congenial concept in the European system, where they even have a phrase, necessity in democracy, but less so in the U.S. System. Nevertheless, I'm happy to report that for the most part, our federal judiciary has been able to stand up to the threats that we've had of late involving detentions and other limitations of speech and freedoms in the United States. So let me just turn to some instances of militant democracy that, as I said, are more fulsome in this article, where one might consider militant constitutional democracy as something that has a historical dimension and perhaps even is best understood as part of a political context in Europe that really pertains or relates to post-war Europe. So what do I mean by that? If we look at the European Convention on Human Rights, as well as the post-war constitutions in many states, they've baked in militant democracy. And so the rights protections, for the most part, there are a handful that are non-derogable, but the rights protections, for the most part, including freedom of speech, freedom of assembly, many of the privacy rights, explicitly have language, both the national constitutions and the European Convention, that allows for a jurisprudence of militant democracy. It's a set of balanced rights that involve preservation of democratic society. This is nowhere defined, but it's very clear from the language that the courts are supposed to exercise supervisory functions and that oblige it to pay attention to the principles that would characterize a democratic society. I want to suggest that this idea of this kind of a community or society, a public sphere, this is something very different at the European level, a European approach at the regional level that differs from the United States in at least two key respects. We don't have explicitly balanced rights. Of course, courts in applying the First Amendment, invoke state interest, et cetera, but it's not balanced in order to preserve the democratic society. It's a very different set, different scrutiny and different set of interest. And it also means that it's a different role for the courts, and a different understanding of the public sphere and its relationship to the state. So in the U.S., the values animating the free speech doctrine tend to draw from liberal philosophical values underlying the U.S. Constitution. The rights are often framed in a radically individualist fashion with a related commitment to keeping the public sphere free of regulation to the greatest extent possible. By contrast, in Europe, at both the regional level and domestic, constitutional doctrine relating to freedom of expression has tended to be far more protective of other non-speech related communitarian values, such as preventing social unrest or promoting societal inclusiveness and anti-discrimination values. So let me quickly give you some examples. The European Convention, Article 10.2, recognizes that the exercise of such freedoms and liberties, ones I've mentioned, are limited by justifications, quote, necessary in a democratic society. Again, these are not defined, and sometimes there may be competing rights, but also more problematically, sometimes in terms of societal interest, not to be disturbed, and also more recently, the notion of brotherhood and of connection to some pre-existing understanding of community. I want to suggest that this understanding comes from a certain interpretation of the post-war period where philosophers, a number of political philosophers, understood the dangers of Weimar and invoked the possibility of judges, of the failure of the judiciary at that time, and the idea that a more robust doctrine that could be applied by judges could be useful in protecting democracy. So this is part of the origins of the doctrine. And what I want to suggest, and there are many examples, the Holocaust denial laws, blasphemy, recent defamation cases, but they all seem to stop in a historical moment. The court defers, gives a wide margin of appreciation to the state courts, and problematically in recent cases involving Islam, the practice involving Muslim religions, and any non-Christian, the courts tend to be hands-off and allow for the national courts to balance these rights against some pre-existing idea of what the democratic society is. And I think this is really key. There's a conception, and again, if we're going to have deference to judges and they're applying an understanding of democratic society, it would be important to think that there would be some evidentiary inquiry as to what extent is this quote unquote necessary in a democratic society. And that is really the linchpin, is the absence of evidence in almost all of these cases, or that kind of scrutiny. So let me, I know that time is short. I would say that the headscarf cases that started with Sahin versus Turkey in the European Court of Human Rights, where the court sustained a wide margin of appreciation involving cases involving morality, sustained the ban on the headscarf on the grounds of necessity in a democratic society. I can tell you that whenever I arrive to Heathrow, it's not just headscarves, it's burqas, it's turban. You're talking about a diverse and very fulsome democratic society. The same thing is true in the United States. So obviously, there's an understanding in Europe that is very different than what is going on in other places. A more troubling set of cases, Refa Partisi, involved exclusion of the Sharia party, where the European Court of Human Rights just repeated that it was, that it was necessary to preserve democracy to exclude the party. And then, and there was no evidence of violence, and there was no principle involving violence, which of course would be problematic if we're talking about a terrorist party. The most recent kind of, problematique was set out in SAS versus France involving the niqab, where the French court, the High Court in France, found that not security and not women's rights, but living together was the basis for excluding the niqab in France. And actually, some people were arrested at an opera because the opera was being filmed and they were wearing the niqab in the front row. It was actually a Persian opera where there would have been plenty of such garments and religious garb on stage. But in France, this is punished by a fine and re-education. So we have to ask ourselves, and there are many such cases, what is fundamentally at stake here? The dilemmas that this application of militant democracy implies. The discrimination goes to the question of whether we can trust courts to genuinely identify what are genuine threats to democracy. And again, one can discuss this. What seems clear is that many of the relevant domestic constitutions and the European Convention of Human Rights relate back to a post-war period and this idea of deference with respect to particular areas. Obviously, the German Constitutional Court with respect to its supervision of political parties, and the European Court has taken that role with respect to the Islamic parties and also earlier on in the Cold War to communist parties as well. So I want to suggest, with my remaining minute, as I said, in SAS versus France, the European Court concluded that the niqab, the burqa, was a threat to fraternity with all of its brotherhood and wartime provenance, suggesting that sociability was the key to preserving democracy. But I think here we have a dilemma, a fundamental dilemma. The more that we exclude people who are minorities, religious minorities or political minorities, the more we run the risk of that lack of sociability and a threat to democracy. And this is something that seems evident historically, as we can see the crumbling democratic direction in Europe and indeed in other parts of the world. But I want to end on a positive note, which is that in the U.S. we've had a number of recent cases, and I have some language here from a recent case filed by the American Association of University Professors. As you know, there's been federal government pressure on what we can teach and how we manage university life. It's been wonderful to be here. It's been nice to get away. But what's great is that the judiciary has been able to rise to the challenge. Have they done so by limiting democracy in the name of democracy? Actually not. The definition of democracy has been shaped by the protection of these rights. So let me just share this last quote. From the judge in the case of AUP out of Massachusetts, and they it was a case that went to the visas, the attempt to control student visas. How we treat our guests is a question of constitutional scope, because who we are as a people and as a nation is an important part of how we must interpret the fundamental laws that constrain us. We are not, and we must not become a nation that imprisons and deports people because we are afraid of what they have to tell us. American Association of University Professors versus Rubio. So I leave you on that comparative note, and then we can perhaps have more discussion.
Thank you so much, Ruti. And now we go to Professor Sandberg. Please, you want to, or you are here already? You are fast. Please, go ahead.
Just want to put up my presentation.
Could you put his presentation?
No,
Can you hear
this
me?
is what I'm doing now. Okay. Thank you, Shimon, for inviting me for the second time. Last time I talked in the Corona era in front of empty hall. Is it my first time for
That was
in front of audience?
COVID-19. But you were recorded forever in YouTube. So don't
I didn't
be,
know that.
Don't be
But today I am also recorded.
disappointed. You are recorded today with people. But
Thank you, Nicholas, for the wonderful hospitality. My field is property law, and courts are meant to shield private property from improper government action. And there is one area in Israel, at least one, where such protection has become intensely political. Everybody knows that there is a sharp debate inside Israel and outside it regarding the political future of the area called Judea and Samaria, or the West Bank. Israeli government contend that it is entitled to establish settlements in the area. The Palestinians and others think that settlements are illegal. Now, according to the internal legal paradigm that has guided all Israeli governments for many decades, the government is permitted to initiate the establishment of Israeli settlements only on public land and not on private land owned by Palestinians. Therefore, Israel's policy on this issue, which is politically controversial, is largely based on mechanisms for determining land ownership, whether land is private or public. This issue is particularly complex in the area of Judea and Samaria for several reasons. I will just mention two. A large portion of the land is not registered at all, and there are no reliable registries. And the land law upon which the private ownership is based are complicated, old, and vague Ottoman laws, which are based on acquiring a prescriptive title through agricultural cultivation. Almost every Israeli action in Judea and Samaria or West Bank relies on a professional interpretation of old legislation and historical aerial photos. And in a system with these flows, mistakes in good faith as well as manipulations can occur. Decisions regarding whether a certain piece of land is public or private have conflicting potential results. If it is wrongfully decided to be public, it deprives private Palestinians owners of the land. If it is wrongfully decided to be private, it may deprive Israeli settlers who receive the land from the government, believing it was not private. Now, the struggle for the private and public land has become a central focus of both the Palestinians and Israeli political fight over the future of the West Bank. Now, a major arena of this struggle is the legal arena. And Palestinians and settlers approach the Israeli Supreme Court for relief. As a result, the Supreme Court becomes the final arbiter on the issue of settlement evacuation. Every decision of the Supreme Court on such issue that are ostensibly legal questions in property law becomes a component in the larger political and diplomatic issue facing Israel, the political future of the settlements. This triggers criticism from every side, as those who disagree with the rulings view them as political interference by the court. The judges themselves are divided on the outcomes, and the division between them is perceived by the public as a political disagreement over the results rather than a legal one. The court falls into a trap that it cannot escape. An extreme example of this, which was a critical milestone in undermining the legitimacy of the Israeli Supreme Court, was the court's decision in 2020 to annul a law passed by the Israeli parliament known as the Regulation Law. This law aimed to legalize the establishment of 26 settlements in Judea and Samaria on land, some of them were private property of Palestinians. And the legal concept underlying this law was the concept of good faith. When a person builds structures on land that is not his, while in good faith, believing that it is their own, and the value added to the land by the construction exceeds the value of the land without the structures, the builder has the right to compel the owner to sell the property at the value of land without the structures. Now, the Supreme Court ruled by a majority opinion to annul the law. It did so because, in its view, the law violated the private property rights of Palestinians as it set overly broad criteria of determining good faith. The dissenting judge, Judge Noam Solberg, believed that the flaw could be corrected by establishing more detailed criteria for the good faith standard. But the majority of judges were unwilling to give the legislature an opportunity to amend the law, and the direct consequence of the annulment of the law was the potential destruction of settlements. And this was apparently one step too far. Immediately after the publication of the ruling, a day after it, on June 9, 2020, the then Speaker of the Knesset, who currently serves as Minister of Justice, but then he was Speaker of the Knesset, published the following response. You can read, but I will read it. The Knesset, the Parliament, will no longer remain silent in the face of ongoing infringement of its powers and status. The Supreme Court has once again trampled on Israeli democracy and the basic human rights of many Israeli citizens, referring to the settlers' rights. The Supreme Court is taking giant steps towards a constitutional crisis unprecedented in Israel. And given that this text was spoken in 2020, it is a self-fulfilling prophecy. So, the constitutional crisis indeed emerged after member of Knesset Levin was sworn as Minister of Justice on January 4, 2023. Levin publicly announced his intention to carry out a judicial reform. The reform had, surprisingly, two main components. One was to limit the Supreme Court's authority to annul laws. The second was to change the composition of the Judicial Selection Committee so that the relative weight of judges would decrease and the influence of politicians, especially those belonging to the ruling coalition, would increase. And the reform proposed by Levin elicited sharp reaction both from parliamentary opposition and from the broader public opponents of the government, and even the president of the Supreme Court criticized, of course, this so-called reform, and said that this plan is not to reform of the judicial system, but it's a plan to destroy it. Now, the judicial reform was labeled by its opponents as a judicial revolution, and masses began protesting in the streets. And probably you know all this, so I come to the last issue. What I now described in front of you is show that within the Israeli complex political reality, the Supreme Court of Israel is trapped in a dilemma from which it can hardly escape. It has become an integral part of the political arena. And every decision it renders, even in ostensibly neutral, technical, civil matters of land law, will be perceived as supporting the political outcome that follows from it. And former Chief Justice Aaron Barak which you see here, once recounted that he asked his predecessor, Meir Shamgar, about their joint role in developing the Supreme Court authority to invalidate laws. And he asked him, why is that when you, Shamgar, jumps into a wet pool, you comes out dry, whereas when I, Barak, jump into a dry pool, I comes out wet? Shamgar replied, who is the fool who jump into a dry pool? The Israeli Supreme Court is now deep inside the pool, completely soaked. The question is whether it will be able to become dry again. Can you recommend how he can get out? Thank you.
Thank you very much, Chaim, for your analysis of the role of the Supreme Court in context property situation, but indicative of the general situation. Yeah, and now I ask the management, technological management, to put Professor Hiram Chodush to give us his presentation together with Professor Eric Helland. Welcome, both of you. And we appreciate that you got very early this morning of your Friday in order to speak to us on the evening of Thursday. So we are really grateful for the special effort you made, and we are all ears to hear your presentation and learn from you what are your insights and what are your reflections on the subject of this conference.
Thank you, Shimon. And luckily, Eric and I share a common habit of waking up probably about 4 o'clock every morning. So this is our good time. It's wonderful to be with you, but sad that we're not there in person. Many apologies. We had so looked forward to joining you there. And many thanks to Shimon and to Nicholas for organizing such an outstanding conference. We can't really wait to read all the papers. Eric and I, in our last chapter, framed a very large set of challenges and agenda that we called measuring justice. Obviously, there's a paradox in measuring justice. It's both impracticable and it's necessary. There are huge questions of conception, definition of what justice is, the role of the courts in society, how we develop comparative measurements of independence, what the relationship is between independence and impartiality, the relationship to justice itself. And our dual goals are really to understand as much as we can, but also to improve the conditions of justice in society through the courts and through other institutions and through the society itself. We focus a lot on methodology, on trying to deepen our theory, improve our empirics, and the agenda is also dual, one of research and reform. We're concerned with big challenges, the neglect of judicial institutions. I would say that the judiciary is not only the least dangerous, but the most neglected branch. Since the falling of the Berlin Wall, we all know that we saw a wave of democratic commitments to the rule of law, liberalized economies, going from autocratic states to democracies, going from top-down command economies to private economies focused on contracting. And we haven't invested in any sort of proportionate way in our judicial institutions. To understand this, we often find our theories a little bit weaker than we want, our empirics a little bit less developed than we want, and also reform efforts around the world tend to be shallow and ineffective. And so our goals here are to dig deeper into judicial independence, and I'm going to let Eric walk through one of the many conceptual steps that we're taking, which is the concept of political equilibrium. But as time is running out, a little bit on me this morning, I just wanted to also say more generally that as so many of these presentations have underlined, we have both a responsibility and an opportunity to do more than just merely understanding and measuring the judicial independence needle. Yes, we need rigorous scholarship, theoretical understanding, empirical measurement. And in future conferences, I hope that we'll continue to focus on surfacing and engaging those experts who are engaged in more than creating the needle. They move it. And by answering in practice, how do we achieve greater levels of equilibrium and judicial independence, more effective institutional performance by judiciaries to realize rule of law objectives? By rule of law, I mean self-limiting, effective statecraft and greater justice outcomes for the societies we serve. So in sum, I think this is how we give life, Shimon, to the Mount Scopus guidelines in practice. So many thanks to you all. I'm now going to turn it over to my dear friend and close colleague, Professor Eric Heller.
Thank you, Hiram, and thank you. And again, I express the same. Wish we were there, and not grading a bunch of intro econ exams. So I wanted to start this with just what were we thinking about when Hiram and I sort of first put these ideas together for sort of trying to think about how we could do measurement. And there's kind of a standard account in kind of empirical legal studies, which really is that courts exist to enforce contracts, property rights, protect civil liberties, political rights, and that there is this thing called judicial independence that's almost a discrete institutional feature. And I think we kind of, I'll implicate you in this, Hiram, I think we kind of fell into that trap. We were looking for ways to think about how we could measure independence in some way that we could say the judiciary is independent here, the judiciary is not independent there. I think our findings, kind of to summarize it a bit, were that it was really underpredictive. We could find examples of the judiciary we all agreed were sort of independent, but had very different institutional features from ones that by the institutional measures of things like lifetime appointment or not having salaries be measured, ones that a lot of people in the empirical legal studies tradition have collected data on. And so the emerging idea that we've been sort of, and I say emerging because I'm not going to give you any definitive answers today, but in Hiram and I discussions has really been one of what we're thinking of as a political equilibrium. And interestingly, it kind of came out of two events that have already been mentioned. One is the events in the US, but also the events in Israel, right? The idea that there is this very different sort of political context going on around judiciary in these two countries. And so we've been trying to think about how we could sort of fit that into a framework to think about judicial independence, and what that would mean for sort of data collection. So to think about kind of these examples, and these were the three that we sort of had in mind in the paper, one would be the United States, and kind of particularly the polarization over the Supreme Court and the Dobbs decision. Is the Dobbs decision an example? And again, we're not being normative here. We're thinking about this more in terms of what we would gather information, rather than our views or whether or not this is a good or bad thing. But if you think about Dobbs, it was signaled for 50 years that this is what the conservative legal movement wanted to do. And yet it's been greeted as kind of a crisis of legitimacy. But is that actually the example of an independent judiciary? And then the situation in Israel, it's been talked about already, sort of in this conference. And then another one on our radar was Hungary, where you had a diminishment of judicial independence. It was, as far as the surveys can tell, broadly sort of popular with the public. And so we've been kind of wrestling with how we think about these, where formal protections remain on paper, but judicial autonomy, influence, and legitimacy can sort of move in different directions. And so that kind of led us to this idea that independence is not really one thing where we say this judiciary is independent, this judiciary is not, but it's really a political equilibrium that involves kind of institutions, political incentives, and public support. So here's our very simple equilibrium model. This is what happens when you write a paper with an economist. They write down an equation. But I will say this equation probably doesn't capture much more than what I've already said. But just imagine that you have these three tolerance thresholds, right? You have political actors, maximum tolerance for assertiveness. We just heard a discussion on this in the context of Israel. At what point is there an effort to pack the court, strip jurisdiction, etc.? There's the public. What's the public's tolerance for assertiveness? Again, Israel is a really interesting context in this. And then finally, what's the sort of the system's accountability, right? Hiram and I have this puzzle that we've been wrestling with in our conversations, which is, can you have two independent judiciary? Could this be a problem for a country? By all our measures, the judiciary appears independent, but is in fact making rulings that are, say, inconsistent with the rule of law or something like that. And I think we could come up with some examples of that. So we were thinking about sustainable independence as what's the minimum level of those three that would sort of produce a sustainable level of judicial independence. And it's really the way to think about it as, again, an economic modeler is what's the like minimum tolerance that the system between kind of political accountability, public support, and the institutional features would kind of support in terms of judicial independence. And I'll give you one example. I would say California has a pretty independent judiciary, but very different institutions than the federal courts in the United States. Judges in California stand for election. That does limit their sort of independence in an institutional way, because unlike federal judges, they could be recalled in an election, and in fact, pretty regularly are. So just to again, because also as an economist, I have to have a diagram. One way to think about this is when you line these up on a preference from kind of a judiciary that's completely deferential to sort of what we could think of as maximum assertiveness, the minimum of one of those three is going to be the constraints. Maybe in my example here, it's public support, but maybe it's the particular political coalitions in the Knesset. Maybe it's the institutional features that come out of the progressive era and mean that we have judicial elections in California that we don't have at the federal level. And so this was kind of the dimensions that we thought of, and we love to, in the comments, have discussions on whether people think these are kind of the right dimensions. But autonomy, which was the extent to which judges can decide cases free from political influence and pressure, and then influence, which are the degrees to which political actors and the public comply with those decisions. You know, legitimacy, right, which is how difficult is it to sort of attack the court, and accountability, right? What are the rules that can sort of strain abuses? So kind of what we're thinking of is, you know, judicial independence is kind of autonomy and influence sustained by legitimacy and maybe disciplined by accountability. So again, the stylized facts would be you could have a high autonomy judiciary, but one with falling legitimacy, right? That might be a situation where as you know, autonomy rises, sort of public support declines. You could have perceived overreach, right? Government seeks to curb the court, and you have public mobilization, for example, what we saw in Israel. And then you could have something like the way we're probably, maybe without enough information, describing Hungary, which is a popular erosion of judicial independence. There seemed to be a broad segment of the public that was not sort of supportive of the judiciary. So these aren't really country histories so much as what we're thinking of as different political equilibriums that we would be trying to measure. So let me conclude then with just how do we see this? If we can't observe independence directly, what we can see is rules, tenure, appointment, salaries. We can see behavior, and we can measure trust and sort of perception among the elites and the public. Each one of those indicators is noisy, but we are increasingly in our research kind of thinking that all of those are important, right? And so you can have formal protections that exist with courts that are kind of captured either by political actors or perceived of as now legitimate by the public. And so rather than treat sort of independence as a discrete feature, we're treating it as kind of a latent variable, the outcome of these. And so with what's our measurement strategy? Well, it's to combine those institutional features and see if we can come up with a single framework that, to Hiram's point earlier, perhaps could give some early warning signals as to when independence is being eroded, right? When is popular support falling? When are political actors talking about removing certain institutional features, or kind of the reverse, when are institutional features underlying legitimacy that we might want to have? Maybe it's not a good idea for California courts to have elections going forward if we want an independent judiciary. So what we're trying to think of is moving from sort of static indices that exist in the literature to some sort of equilibrium approach to this. And this is all at a very high level. We're still sort of thinking this through, but we're hoping to sort of have some more time to kind of think about this over time. And then I guess the last thing I would say is just to sort of kind of summarize something Hiram said earlier, and then I'll turn it back over to Hiram, which is really the reform agenda here is, could we come up with measures that broadly capture this independence equilibrium in ways that would allow us to say, you know, here's some information that gives us perhaps earlier warning signs than street protests or things like that on things that might be sort of concerning. And so with that, I'm going to turn it over to my colleague, Hiram, if you had any concluding remarks, since I think you still have a few minutes left.
Eric, excellent. Just to underline that, the underlying theory or the measure that goes into equilibrium has a really profound impact on what reform strategies you deploy. It's just that we have tended to think about, through a more static lens, those reform efforts as being the terms of engagement, the terms of employment, in some cases with the judiciary. And we haven't considered as well some of the other factors that Eric lays out in this model. And so it's interesting to think about reform activity strategically deployed to attack those particular dimensions that are causing the problem to go out of equilibrium. And with that, we'll conclude, Shimon, and cede our time to the other distinguished guests and discussion.
Thank you, Eric, and thank you very much, Hiram. I must say that your analysis, if I translate it to Israeli reality, it comes as you can get a Nobel Prize for this, because what we saw is the worst decision that the Israeli Supreme Court made is to allow someone who is charged with criminal offenses can form a government. And at that time, in my opinion, the court felt it does not have the public support. But then at the end of 2023, after hundreds of thousands of people went to the streets, as you mentioned, Eric, then they got a feeling of support of the public, and then they ruled to strike down constitutional amendments in 2 cases. How could you explain the assertive independence in your language in these 2 cases with a totally unacceptable, morality-wise or properly-wise or good government-wise, that they allowed, while they had let's say, legal infrastructure in our system, not to allow it. So I think from the point of view of the Israeli, you have a laboratory to develop this study, and I commend you, Hiram and Eric, for this very interesting, and that gives us a work plan for how we introduce equilibrium independence, independence, and not just judicial independence, because it is a triple-based independence. Thank you very much for the effort you made to get up so early. And now we have another California person, Professor Maimon Schwarzschild. He is your neighbor from University of San Diego. Maimon, please.
Thank you very much, Shimon. The hour is late and the time is short. But as switch on the micro. And getting shorter every minute. The hour is late. The time is short. In reflecting on the very, I think, fruitful and productive words and papers that we've confronted today. It seems to me that one of the prevailing themes across the day is the theme of the two different challenges to judicial independence. One, the external challenge, and the other, the internal challenge. External challenges, there are examples from around the world. In the United States, where Ruti and I live and work, there have been dramatic examples in the first years of this decade. Events like the then majority leader of the Senate verbally shaking his fist to the Supreme Court of the United States and telling a demonstration or a mob, "I want to tell you, Gorsuch is a Supreme Court justice. I want to tell you, Kavanaugh, another Supreme Court justice, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions." And in the wake of that, there were demonstrations or mobs outside the homes of those two justices and a few others. Those were crimes in the United States, but the Attorney General, then Attorney General, who was widely viewed as being sympathetic to the mobs, declined to prosecute anybody involved. And continuingly, there are threats of packing the Supreme Court and possibly lower federal courts in the United States. Those are just American examples of external threats from political or other sources, external threats to judicial independence. The other threat, or at least challenge, that's been a theme, I think, today, has been the challenge of internal threats to judicial independence. What's the internal threat? The internal threat is overreach and a reality or a public perception that the judiciary is exceeding the legitimate role of adjudication and the separation of powers, and essentially getting into the business of making controversial laws of a sort that would otherwise be made by elected legislators, and that creates a sense of illegitimacy among the public and threatens actions that will really impair judicial independence in a variety of countries. An example, a concern about that goes back in American history, a long time indeed. President Abraham Lincoln, in a dispute with the Supreme Court in the era of the Dred Scott decision, said in a public address, "If the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal." And President Lincoln didn't propose to resign his policymaking power or Congress's policymaking power into the hands of the Dred Scott Tribunal, which he perhaps ironically called eminent. These issues have I think, dominated the discussion today, and the possible responses to it range across the spectrum from treating the situation in many of our countries as the kind of crisis of democracy and of judicial independence that justifies much greater assertion or efforts to exercise judicial power in ways that would not have been contemplated until recently and under conditions that are not considered a crisis for democracy. The alternative view is that there isn't a crisis of democracy, that there is a crisis, perhaps, of the previously prevailing elites no longer enjoying an unchallenged prevalence in political and social and legal life, and that any further expansion of judicial power in response to the challenge to the foregoing elites is little justified, if I can use the same kind of understatement that perhaps President Lincoln used. There's a phrase in Hebrew, lahavdil, when anybody might be in danger of thinking that you're comparing yourself to President Lincoln, which I would not do, hoping to not to be subject to his ultimate fate. Where does that leave us? It seems to me that across our countries, in European countries, in the United States, in the United Kingdom, in Israel, and in lots of other places, there are moves by from the public and from elected executive and legislative bodies to reform, or on another view, to attack judicial independence. On one view, in other words, in order to ensure the proper separation of powers, and on another view, to diminish the legitimate powers of the judicial branch. How to deal with that is compromised or qualified by the fact that also in essentially all of our countries, in the European countries, in the US, in Britain, in Israel, and elsewhere, there's a growing polarization, a growing divisiveness, and a lack of useful and meaningful dialogue and effort among people in reasonable equilibrium to resolve these issues. And I think it's in that context that this institution that has been so well represented today, and which Professor Chatrit has founded and kept going over the course of the decades, is a very hopeful sign in a generally rather bleak picture around the world of providing a forum, as we've seen today, of a quite broad spectrum of views about specifically these issues. And it's clear that in each of our countries, how to deal with the actions of the judiciary and the actions of the public and the coordinate political branches is going to continue to be to reflect the divisiveness and the mutual misunderstanding that increasingly seems to prevail in our countries, and so that this forum going forward, being able to, in a reflective way, provide, if not solutions, at least a range of reasonable alternative solutions, is something that we have reason to be extremely grateful for. So on that note, just a word of great gratitude to everybody who's been involved, to Shimon Chatrit, to our hosts today, and to everybody who participates in this now long ongoing, and I hope under growingly difficult circumstances, continuing process in the weeks and months and years to come.
Thank you very much, Maimon. And now we wish to hear Elina Asimakopoulou for her presentation. And after that, we will invite our good friend Nicola. Please, Elina.
Thank you. I will try to be very brief. We are all tired, and thank you for being here so late. But first of all, I would like to express my warmest thanks to organizing committee and especially Professor Nicolas Kyriakidis for inviting me in this very inspiring discussion, and I'm very happy to be here among you today. So, judiciary and democracy. According to my view, and many of the comments I want to make have already been mentioned, means and meet judicial and democracy basically in the notion of public trust. And I think that the discussion must be concentrated on what this public trust, what are the components, the legal components of of the notion of public trust. For example, the reasoning of the judgments, profound reasoning for also both procedural and substantial matters. Access to justice, the safeguarding of the so well-known access to justice, and the assessment of judicial reforms by the context that they intend to ensure. And of course, the safeguarding of fundamental values of judicial systems. Before going to each one of these points, I would like to emphasize as an important, I think, point that legal reforms serve actually as the mechanism by which institutions evolve to meet new social, political, and technological challenges. Moreover, at the prior and at the subsequent also stage, so before and after the legal reform, judiciary through judgments shapes the normative paths of democracy. Courts articulate the scope of rights, and very often in a way, they push law changes. In any case, we need legal reforms in order to protect separation of powers. Concerning the above-mentioned specific elements of justice and democracy and the intersection at the point of public trust, I just want to say some things about reasoning I was referred to, about what access to justice means, according to my view, and this mainly has to do with the procedural rules, especially the fact-finding rules, and the tension is to lose these rules in order to emphasize on the fundamental right of access to justice and facilitate the effective implementation of substantive law. Take into account that substantive law, legal rules, increasingly protect fundamental human rights, and I will come to this again. So, substantial and procedural access to justice is the legal inspiring for legally reforming the judicial power and the society. The assessment of judicial reforms must be made by the social context that they intend to ensure. This is, in a way, the teleological method of interpretation is substantive and procedural rules also. We need teleological interpretation in order to safeguard the rule to fair trial and the ultimate goal, that is the ensuring of the rule of law. It's like a permanent inner reference to justice as fairness, as John Rawls cited. Special emphasis must be done to the evolving protection of human rights in the frame of civil procedure, of civil courts. In a way, we have a private enforcement of fundamental legal values. Human rights, the concept of this protection, has been incorporated into the objectives of procedural law through the applicable substantive law, and the examples for this, and I'm talking inevitably as a European legal, competition law, discrimination law, environmental law, there are fields of law that service interests beyond the strictly personal interest of its litigant. The protection of fundamental rights in civil courts is the legal reform that leads to this legally based moralizing of claims, in a way. If I would like to say it in a single phrase, the impact of economy and technology on the justice is redefined through an ethical discussion based on the legal provisions of fundamental human rights. This discussion is the basis of the evolving legal reforming today. At this point, I would like to mention also the recent published report of European Union Agency for Fundamental Rights on Human Rights Aspect Assessment in Lawmaking. There we see that European Court Human Rights Case Law, Court of Justice of European Case Law, the general principle of proportionality, which is taken into account when implementing measures through EU law member states, independent bodies of member states such as equality bodies, EU Fundamental Rights Information System that brings together information on the human rights commitment and compliance. All these are factors to promote human rights commitment for lawmaking. And some specific examples in which judicial activism pushed in a way legal reforms. For example, discrimination law, European discrimination law, environmental law, climate change law. Latest developments, especially the judicial activism of Klima Signorinen case of European Court of Human Rights, that leads to the formation of private enforcement of environmental law. And we see already normative in Directive of European Law 2024/1716 for the civil liability of companies for infringing environmental law. Latest need to safeguard is freedom of expression. is the most characteristic for me example of how civil justice, and specifically procedural law ruling, defines pluralistic democracy through maintaining standards for the protection of the freedom of expression as fundamental right, and the right of the citizens to information through protecting free journalism and enhancing public debate. We have the so well-known SLAP directive of European Union for the protection from abusive proceedings. SLAP directive means strategic litigation against public participation. And this directive includes a characteristic provision that is a characteristic example of the legislative response to the judicial demands and the needs of society. What we see in Article 21 of this directive, member states shall provide the Commission with the available data regarding the application of this directive, in particular available data showing how those targeted by court proceedings against public participation have used the safeguard provided for in this directive. And so on, just to not be so informative for you. That report shall provide an assessment of developments with regard to abusive court proceedings against public participation and the impact of this directive in the member states while taking into account the national context, the particularity we said before, in each member state. If necessary, that report will be accompanied by proposals to amend this directive, and the Commission report shall be made public. This means that is a very characteristic example of what a social assessment of legal reforming and social impact assessment is. So concluding, for me the most important way legal reforms support democracy is by protecting fundamental human rights. Is this humanist approach of justice today? Democracies rely on freedoms of expression, association, participation, and reforms that expand civil liberties, allow citizens to voice opinions, access information, and participate meaningfully in public life. When reforms strengthen human rights protection and the judicial enforcement, they reinforce inclusiveness and fairness essential to democratic governance. This subsequently and inevitably enhances public trust to justice as democratic institution. Thank you.
Thank you very much, Elena. I think we'll take 5 minutes for questions and then we do the concluding remarks. Amnon, you... Very briefly. Yeah, go ahead.
I think just to follow up on Shimon's earlier comment, I think that this panel was very important because it added another dimension to our thinking about judicial independence, not only context vis-a-vis technology, but also context vis-a-vis the perception of the other forces in society. So judicial independence is never a standalone concept, but rather it's a reaction to zone of tolerance. I want to suggest that the idea of zone of tolerance, I found it first in a 1941 article in the United States talking about zone of tolerance. But the problem is, and this is what we'll have to maybe in the next conferences, or maybe we'll devote some time to this, is the exogenous endogenous problem, because the tolerance of one branch is also the intolerance of another branch. So judges react to what politicians do, politicians react to what judges do, they both react to what technology does. So we have to think further, because these are not independent variables, they are dependent on each other. So that's a challenge for us.
Thank you, Amnon. Please.
Thank you. I have 2 questions. First question to Ruti with your title, Militant Democracy. I was a little bit irritated by that. But then you referred to the German constitution, basically. Well, not only, but also, I guess, and to Weimar, the Weimar experience. And, well, but in Germany, we use the term translated defense-ready democracy, which is, I don't know, it sounds like better for me. So my question is, why are you militarizing it so much, the term? So what is the intention? Just, I mean, to...
This is because the
So-
other side is fighting with us, so we want to be fighting with them.
Okay, defense. Yeah. Anyway, just a suggestion, or you may comment on that.
Defensive
whatever
democracy,
the reason
okay.
is. And my other question is to Professor Schwarzschild. Yeah, I think. Yeah. Excuse me. It's late, but to you. And if my question is, if I have understood you correctly, that you were basically saying that what we observe in the United States and in other places of the world is not so much a fight against democracy through fighting judicial independence, but because that's a story which is often told, that and I'm always irritated by the I'm always irritated by the fact that democracy and the rule of law is somehow mixed up in this. But you said it's more elite project to say that judicial independence should be defended, although it's just a reaction to overreach, judicial overreach, or is it? Maybe you can comment on that.
Ruti, do you want to go first? Or?
Sure. Thank you very much. Yeah, just on the, well, I like the comment, made about the fact that part of what unites the theme here is thinking about society and some other, not just the state and and rights talk or the state and these these forms of expression or democracy in some kind of atomistic or abstract way. So I think that's right. I was citing, I think the term has been used a lot. In German, you used one definition, but in my piece, which is in the Michigan Journal of International Law, I'm happy to share the site, there's a footnote, Streitbar Demokratie, and also Karl Lowenstein in 1937 in the American Political Science Review, and he was the one who advocated, he was talking, and of course, at that time, the concern about the weakness of democracy in Europe and in Germany in particular, and he talked about promoting democracy by all means, and used the term himself. The article was entitled "Militant Democracy and Fundamental Rights." So I'm not talking about militarizing; it's rather this idea of being so vigilant about democracy that you limit rights and actually part of what my piece is, 2/3 of it is a critique, and that the European Court of Human Rights is using that kind of language in order to limit often Muslim rights in Europe, and that they do so at a cost, because the more groups are excluded, the less fulsome you have of a basis for a true democracy where there's multiculturalism and consociationalism. So I think he was right. Anyway, yeah.
Your question, I think, evokes the fact that a judiciary is almost in its nature, the word was used earlier today, an aristocracy. And in a sense, that's inevitably right. Judges are not elected, and they have an expertise. Almost invariably, they are the graduates, not just of postgraduate elite institutions, but people from a very elevated and potentially out of touch high status and high stratum of society. That said, it's surely true that any liberal order requires a judiciary and requires judicial independence within its proper sphere. The danger, it seems to me, to that judicial independence comes from unjustified challenges from the outside, but it also comes, and the two are related, from overreach and from abuse of judicial power in order to become partisans in the culture wars and legal wars and social wars of the time. And that internal overreach, to the extent that it exists, promotes and provokes and can seem to justify the external threats, which reduce the standing of an independent judiciary, which within its proper sphere is essential to the success of any liberal society. So that's, I think, where I was trying to go with that. And it's not a suggestion that all efforts to by executive branches and by legislative branches to constrain the judiciary are legitimate. Some are clearly not, but the context in which they arise is at least the public perception, and one can give examples across the world at this point, from all of our countries, of judicial actions and judicial interventions, which is very difficult to justify. And to the extent that that's the context in which we're operating, the threat from legitimate and not so legitimate of constraining or undermining the judiciary becomes all the more powerful and all the more sinister and all the more threatening. And so that's the kind of dialectic which I think increasingly we confront in societies that are increasingly very divided and tribalized amongst themselves.
Thank you, Maimon.
Lots. I can.
Yeah. Thank you, everyone, all the speakers of this panel.